Right, I beg to mention, my lord, item number 4, my lord. In this case, I want to file on additional affidavit.
As a matter of fact, these matters have wrongly been listed in the category top of the list. But they are new files actually.
Yes, Lord.
And Council Mr. Purkar placed for and is granted time to file additional affidavit
Yes, Lord.
on behalf of the appellant. List up to 4 weeks
Obliged, Lordship.
for orders.
Obliged, Lord.
My lord, I will be allowed. I have for item number 2, my lord.
2, yes.
Yes, my lord. I have not received instruction yet, my lord. I will be allowed further time
You appear for
for OP number 1, 2, 5, 6, and 7, my lord.
1, 2, 6, and 7.
1, 2, 5, 6, and 7.
You are standing counsel.
Yes, your lord.
Standing counsel MS so and so appearing for the response numbers 1, 2, 6, and 7. Submit that she has not received instructions and needs some time to do the needful. List after 4 weeks for orders.
Deeply obliged, your lord.
Name of standing counsel shall also be reflected in the this as counsel for response number 3, 4, and 8.
May it please your lordship. With regard to item number 21, lordship, here also Mr. PJ Sekia, senior counsel, is appearing, lordship.
Another bench.
Yes, lord. Obliged, lordship.
His name is not there. His name is not there, madam.
His name is not there, but he has been appearing in this matter, lordship. His name is not reflected for some reason, lordship.
All right, then all the matters go together. 19 to 21, another bench.
I'm appearing for respondent, your lordship.
We'll mark it.
Deeply obliged.
29, lordship. Item number
29 or 21?
29, lordship.
29, you said 21.
No, lordship. 29.
29, another bench. It is stated that the senior counsel, Mr. PJ Sekia, represents the appellant in this case. Appellant,
Yes, lordship. for
this list before a bench of it. Honorable Justice S.P. Count is not a member.
Obliged.
My lord, item number 19, 20, 21. I came for the PWD department. My instructions are awaited. Lordship is directed to file an affidavit on our additional affidavit filed by the appellant. Can it be, my lord, after a week, ma'am? I will file the affidavit.
Standing counsel for
Can even 21st, my lord.
as jointly prayed, list on 21st so as to enable the standing counsel for the PWD to file the affidavit in terms of the earlier direction.
Obliged.
Deeply obliged, lordship.
May I please your lordship?
Yes.
Lordship, with the consent of the respondent, lordship, I beg to mention item number 22 and 23, lordship. Lordship, my senior counsel is other station right now, lordship. Kindly give on next week.
Who is the senior counsel?
Mr. Borgo, S. Borgo, lordship.
As Burgoyne doesn't appear in 23. There is no, his name is not there.
Lordship, yes, as per the office note, lordship, dated 10/8/2018, lordship, we filed the Vakalatnama, lordship.
It's Vakalatnam on Mr. S. Burgoyne, appellant, land counsel who represents the petitioner हो जाएगा 22 में और उसमें appellant हो जाएगा. Is not available today. List up 2 weeks as prayed.
Obliged, lordship.
For the cases.
May I please your lordship? Lordship, with the consent of the appellant, I beg to mention item number 10. Lordship, I need 2 weeks time to file our rejoinder, lordship, on some factual aspect.
And counsel for the appellant placed for, you are for the Union of India.
For the respondent.
Respondent placed for and is granted time to complete her instructions and file. What do you want to file?
Rejoinder, lordship.
Rejoinder affidavit.
My lord, I am paying for fixing the matter after 25, my lord.
List on 13th September as prayed.
Item number 30, my lord. Have you informed the appellant side? I go for the private respondent. My lord. I'm seeking some accommodation. The arguing counsel is out of station today. M. Sharma.
Mr. M, it is stated that arguing counsel, Mr. M. Sharma is not available today. A request is made to adjourn.
Next week, my lady day.
Not next week, sir. List on 19th September as prayed.
Okay.
May I please, your lordship? May I pray for listing of 2 writ appeals, your lordship, tomorrow, your lordship. These matters relate to eviction, your lordship. Honorable single judge was pleased to dismiss our petition, your lordship.
When was the order passed?
Your lordship, that was a week back, your lordship.
2 weeks back.
Lordship.
So what is the?
Lordship, ultimately on 10th is the last date given by the authorities, your lordship.
All right.
Tomorrow is the last date.
Get it listed tomorrow then. Very well.
Obliged.
May I please, your lordship? I beg to mention matter for listed for orders, lordship. If matters become infructuous,
All right. Day after tomorrow.
much obliged.
Daily list for orders item 6.
May I please, lordship?
Yes.
Lordship, the-
Copy as
Yes,
the file has come.
downloaded, lordship.
Yes.
Lordship, may pass necessary for issuing notice in the writ appeal, lordship.
Issuing notice in the writ,
In the writ appeal, lordship.
writ appeal.
Yes, lordship. That was revived by this honorable court.
It was
It was revived.
revived. All right.
lordship, by order dated 6/6/2022.
6/6/22.
Lordship. Order passed in WPC 6935, lordship.
All right. Issue notice of the writ appeal to the respondent. Why the original file of writ appeal is not available?
Lordship, that was missing, lordship.
That is also missing.
Yes, lord. There's a lordship passed order for downloading the website.
To the respondents, steps for service. The file of writ petition number 6935/2014 shall continue to remain tagged with this writ appeal.
Much obliged.
Item number 7.
Rule is made returnable in 6 weeks.
My lord, in this case, my lord, I am for respondent number 7, my lord. I will retire on the 2nd of January coming year, my 2024, my lord.
As a transfer matter,
It's not regularized, my lord. Then, my
it's
lord,
not, it's a matter pertaining to.
Regularization
of master workers.
Hmm.
What had happened, my lord, this writ appeal was filed. My lord, it was dismissed for default.
We had asked you to submit the cause list.
Cause list, my lord.
Let us see. It was not there. Name is not shown.
Name is not shown.
All right. What do you say? What, do you have any objection to restoration?
my lord, I have no objection, my lord.
All right. Mr. Borpuzari has shown to us the cause list.
My lord, dated 19 February 2016 and 29 February 2016.
19 February 2016 and
29 February 2016.
29 February 2016.
My lord,
This was dismissed on 29/9
my lord, 29 February, my lord.
February.
Yes, my lord.
And urges that a bare perusal of the matter was listed at serial number.
My lord, it was listed, my lord, at serial number, my lord, 11.
And submit that the matter was listed at serial number 11 on 29th February
My lord,
2016,
my lord.
on which date, the name of standing council finance,
Sending council finance, my lord.
the names of none of the standing council. Is there D. Saikia?
No, my lord, what had happened, my lord, in the interim period, my lord, they were, my lord, relieved from the finance department. And these new. set of
Standing council of the standing council finance is mentioned, Ms. Bo.
Absolutely, my
So-
lord, no, my lord, what I'm submitting, my lord,
Hmm.
my lord, B. Circular, B. Google, they were.
Forget about it. SC finance is also mentioned.
SC finance is mentioned, my
Then-
lord, but they did not appear. Those standing councils. who
The Mr. R.H. Rahman, Mr. H. Rahman,
My lord,
on that day, name of Mr. H. Rahman and J. Huda, MS J. Huda
my lord.
was mentioned as counsel for the finance department, but they were no longer the standing counsel.
No, my lord, they were the standing councils at that 11 point of time. They did not appear. They defaulted. That's why, my lord, this read was dismissed for default.
So that can that be a ground? They defaulted, you take action against them. That is your problem.
No, my lord, but things, my lord, as it is, my lord, as has been pleaded here, my lord, it was their fault, my lord. They
Your
did-
argument was
My lord,
that the names were not reflected and thus they could not appear.
no, my lord, names were reflected, my lord. Names
Your
were-
argument on the last date, gentleman, Mr. Borpuzari, that was the argument.
No, my lord, names were not reflected on the earlier occasion. My lord, on 16/2, lordship, there is a
The
order.
matter was dismissed on 29/2.
Exactly.
On that day, the names were there.
On that day, names were there, my lord. It is the pleaded case out here, my lord.
Yes.
In my restoration application, that despite of, my lord, reflection of the names of the. my
So
lord,
then, can that be a ground for restoration? Tell us.
my lord,
Anyhow,
the applicant were under
the names were reflected, the names of the standing council finance were reflected in the cause list. but they did not appear
My lord,
to plead the matter before the division bench. Then counsel representing the respondent number 7.
My lord.
What about the other respondents?
my lord, other respondents, my lord, we have taken steps for service of notice on all the respondents for newspaper publication, my lord. And that affidavit is there on record, my lord.
Mr. Rahman appears for the respondent number 7. No one has appeared on behalf of the other respondents despite service of notice through publication. Thus, in view of the peculiar facts and circumstances of the case, the restoration application is accepted. The writ appeal number so and so 392/2015, which was dismissed for want of prosecution by the order dated
My lord,
29/2/2015,
16, my lord.
16
My lord.
is restored to its original number and shall be listed for admission for orders after 1 week.
I'm so obliged.
9-10 आपके यहाँ से attendance. Yes.
I'm so obliged. my lord.
Hmm.
My lord, date may be fixed, my lord. Because I
Will come up after a week, sir.
my lord, I will retire on the 2nd of January, 2024, my lord.
List
I'll retire, my lord.
for orders on 22nd August.
Obliged.
Obliged.
Item number 8,
Interlocutory application number so and so is disposed of. What are the other IAs, Mr. Pujari? The other IAs, IA number 37402484.
Yes, my lord, 2484 is the restoration application, my lord.
Hmm.
And 3770, my lord, it pertains to, my lord, publication.
By rule 20, all
Yes,
right.
my lord. Publication for.
IA number so and so are disposed, both IAs are disposed of.
Absolutely, my lord.
Publication has been done.
Yes, my lord, it is on record, my lord.
Okay.
I have
very
found the original newspapers, my lord. I'm so obliged.
item number 8,
May it please, Lord.
Yes,
I think, my lord, my affidavit for service of notice is on record.
service has been effected.
My lord,
All right. An affidavit for service upon the respondent has been filed, which indicates that service has been effected on the respondent. No one appears on his behalf. List for admission.
Lordship.
List for admission. This was delayed.
Yes,
This was delayed.
delay
Delay
is
has been
controlled-
condoned or what?
delay is condoned very long back. Only,
All right, the legal aid counsel did not appear.
no, she appeared, but the lordship hasn't passed an order, the hard services.
She refused to, she said that she doesn't have instructions. List for admission after a week.
item number 9,
My lord, may kindly pass over the matter for time being. Senior government advocate Dina to appear in this matter, my lord.
Why did you file it before the single bench, Mr. Counsel?
Lord, it was filed before, during the vacation, my lord.
But vacation, you can't mention that it is a single bench matter. Anyhow, what is the matter about?
My lord, what has happened, there is a dispute between the petitioner and respondent number 7 husband.
Also, there is an order of the CWC for grant of custody.
Lord, that is the.
All that is illegal detention, gentlemen.
No.
Challenge that order by filing a petition,
Lord, there
criminal
is-
petition.
My lord, there is no order as such, my lord. My lord, in fact, if your lordship would see the order of the learned magistrate, my lord,
Let's see. Which order?
page 78, my lord. At operative part at page 79, my lord.
Just hold on. There's a case of child abuse registered against you.
Yes,
What happened in that?
my lord, charge sheet has been filed. My lord.
Yeah, so there's a prima facie case of child abuse or of abusing your own daughter.
My lord, if your lordship would see,
Yes, go and file an application before the family court.
my lord,
Let's see the statement of the child then.
my lord,
78,
my lord,
yes.
my lord will kindly see page 88.
78.
Then thereafter, my lord will see page 88. My lord, who has given the custody of the child? What has happened, my lord, if your lordship permits
See,
me?
12/5/23, it is the order of the magistrate.
Yes,
So
and my lord, the husband says that the custody has been given by the.
forget
CWC.
about it. You already have placed on record
My lord,
an order of the court concerned
my
for
lord,
grant of custody. How does then it remain a matter of illegal custody, sir?
my lord will see, there was a proceeding pending before the petitioner and the respondent before the apex court, my lord.
Yes.
There was a guardianship case pending
Hmm.
that was filed in Kolkata, my lord. The honorable apex court has stayed that order, my lord.
What
Proceed.
order?
My lord, kindly see. At page 50, my lord.
See page 90, your own client's message to the CWC. She says that the Child Welfare Committee granted custody, whereas it is the magistrate who has granted custody.
Well, that
Where is
is-
the 164 statement? Let us see.
No, that has not been given to us.
Uh,
My lord, what has happened on, if your lordship would kindly take note of page 66 order, my lord. This is very relevant, my lord.
Yes. Let us see what Honorable Supreme Court has to say.
Yes, my lord. Well, what has happened during the proceeding, mediation was going on.
Let's read the order.
My lord.
This was adjourned. What happened thereafter in the Supreme Court?
My lord, your lordship has seen page 68, my lord.
Yes.
A complaint was raised, my lord.
What after that?
What after, my lord? On
What has happened to the SLP, sir?
my lord, the SLP has been allowed, my lord.
Let us see the order.
My lord, that I have annexed during the pendency, my lord, in the additional affidavit, my lord.
Order dated. What is the date of the orders?
My lord. Page.
122.
Transfer
120.
petition was allowed. That is
Yes.
all.
Yes, my lord.
122.
Yes, my lord.
So that doesn't make any difference.
My lord, on 4/5 also, my lord, they raised a plea. My lord, will kindly see in what manner it has been done. On 4/5, there was a settlement mediation proceeding was directed. The husband, my lord, lodged a complaint before the CWC. My lord, that complaint is also on not record. At 3 PM, my lord, the CWC lodges an FIR, my lord.
Yes. And you've been found responsible in the FIR.
My lord will see the charge sheet.
There is a charge sheet under 75 of the JJ Act.
My lord will see what kind of charge sheet they have filed. my
Whatever
lord.
it is, the fact remains that it is a charge sheet. It is a charge sheet.
My lord will see. My lord will also see the statement made by the husband. He says.
There is a statement of the child that is relevant.
Well, that has not been brought under.
Mr. Nath.
I have received the instructions, on 10th of May 2022. This is the application filed by the husband. I got the copy. Along with the application, kindly see the SMSs given by the daughter to her father.
Our statement has been recorded.
Yes.
Where is that statement? Show us.
Under 164, that copy I don't have because it is a 164 statement.
It doesn't matter. We can see it. Get it tomorrow.
That can be called for. That can be called for from the.
From the, which is the magistrate?
The scan copy here. Yes, scan copy can be called.
Here,
for.
it is in Kamrup.
No,
my lord,
it is in
Dibrugarh.
Dibrugarh.
We'll get the copy.
That is the application. Kindly see along with the application, the SMS is given by the daughter to her father. Considering that, my lord, ultimately the petitioner was contacted by the CWC member. She did not respond. In fact, lordship, the second play, kindly see In the school premises, they have requested the principal that we should be given an opportunity, some space so that we can interact with this child. The second play kindly see.
Hmm.
After that, my lord, when the child was given to the in fact, after interaction, when the CWC has called the child line, from the child line vehicle, the petitioner, my instruction said the petitioner has forcefully
Try to
taken,
snatch.
in fact, snatched the daughter.
Hmm.
At the intervention of the police, my lord, she was my lord, recovered and she was produced before the SDGM. That last order, my lord,
Hmm.
last
Order, the SDGM says, give the custody to the natural guardian.
natural
The
guardian.
natural guardian is the mother as well as the father,
No,
to whom the custody has been handed over.
father to the father.
Who did that?
Yes, that's the question.
On the basis of the SDGM order, may I kindly see last order, 164
Yes.
statement, because here the allegation is against the father.
Who is to decide which legal guardian should get the custody?
No, that, of course, my lord, CWC, we are not, we don't have the
But
authority.
CWC, has it passed an order?
No,
Then how the custody was given to the child, question here is?
it is by on the basis of the SDGM court order, my lord.
The SDGM order you are having, he has also filed it on record.
Yes,
Read it.
the-
There
in
is,
the bunch-
they are a part of the writ petition.
in the-
Read
in
it.
the- in the bunch, my lord, last page, my lord, kindly see, my lord.
Or we have it, Mr. Nath.
No chamber, no chamber.
What does the order convey? Read.
Kiman-
79.
Logic.
Hmm.
Logic. IO has produced victim X and has paid for recording a statement under section 164 CRPC.
Hmm.
Here is the case records clear of the IO for recording a statement under section 164 CRPC. Victim X is escorted by Oman Police Constable so and so. It also transpired from the record that the victim is aged about 11 years and she is a minor. Accordingly, I have recorded a statement under section 164 in
Not
regard to
with
the
due respect to your police officials
logic.
and everybody concerned. This matter could not have been taken to the magistrate. Except for recording 164, there was no business for the magistrate to have passed any order because the exclusive jurisdiction as per the provisions of JJ Act to pass any order regarding a CNCL, child in need of CNCP, child in need of care and protection, is with the Child Welfare Committee. Where is the order of the CWC?
The CWC after this, my lord, in the meantime, because the FIR was lost and CWC did not get the opportunity to pass out.
It is immaterial that the FIR is lost. Custody, either the family court under the Guardian and Wards Act or else the CWC. No other authority can exercise jurisdiction in.
My lord, now the situation is here. Here the situation is, my lord, the CWC, they have interacted with the child at the school premises.
Then they should have passed a specific order of custody or prevented them from doing so.
In the meantime, because of the FIR, she was produced, 164 statement was recorded, SDGM has passed the order. They did not.
SDGM has passed no order.
Logic.
It's no order in the eyes of law. To whom the custody has been given?
To my information, my lord, it is because the case, the petitioner.
What is the order read, Mr. Nath?
No, order
Don't try
says
to
that-
feel so helpless before the court.
Order says to the natural guardian, natural father.
So who is the natural guardian?
Both my lord, father and mother.
Then who decides? To whom this discretion has been given?
To the child welfare. They have,
The SDGM's order to whom does it give the discretion to decide the issue regarding custody of the child?
but because of the case, because of the police case, some confusion has been created, my lord. I have the instruction, my lord, that instruction, my lord, the final order has not been passed.
I would request your lordship
Okay.
to.
Well, we'll issue notice.
My lord.
That is the only way out.
My lord, we'll see two pages, my lord.
Implement, while issuing notice, what else can be done?
No, my lord, since my learned friend has made a statement, my lord, just page 117, my lord,
Hmm.
in the additional affidavit.
Yes. And you have annexed the photograph of the child.
My-
That is again disclosure of identity. What are you doing?
Look that.
Are you supposed to?
At page 117, para 5, my lord.
What are you reading? The application.
Yes, this is an application filed under the DV Act, my lord, where he seeks to seek modification of the.
Why we are bothered about
No,
this
my lord,
application and
a
everything?
statement has been made, my lord, at para 5, your lordship would see.
Uh,
That in the change circumstance took place when the minor daughter Aditi was handed over the respondent. to
Already
the-
he claims so.
And my lord will see page 88 also.
What is page 88?
My lord, the petitioner's sister has been my lord, informed by the CWC. Now they want to change the district of the jurisdiction. My lord, under form 12 of my lord, the CWC, they cannot be given jurisdiction to take her out of the state, my lord. She has been taken on the same very day.
Ultimately, it all boils down
Yes.
to the notice, issuance of notice,
My lord.
issue notice to the respondents. Mr. Nath appears for the response numbers
1 to 6. my lord.
1
May,
to 6.
may I indicate one thing, Lord? Lordship has already pleased to issue notice. We have taken steps.
When?
Service on 11/7, my lord.
All right, yeah, what has happened?
My lord, we have taken steps on all the respondents, including respondent number 7 through email. This has been received, and we have taken Dasti service on all respondents, my lord. They have not appeared, and we have filed affidavit of service, my lord.
All right, then, therefore, that's, notice was issued to the respondents by the order dated 11/7/2023. However, no one has appeared despite service of notice being, no one has appeared on behalf of the respondent number 7 and 9 to 12. Affidavit pertaining to 9 to 12, all right. What about 7? Where is the service?
7 with through email, my lord. Your lordship was had permitted, and
Mail, where is the mail? Where the mail has been received?
Yes.
Whether it is the official mail address?
yes, madam.
Let us see the. There are 3 different addresses.
Yes, my lord. That is my lord. Now he has shifted from Hyderabad to Varanasi, my lord. And my lord, we have also written a letter to the police concern of the jurisdiction of Telangana, my lord, who has informed my lord that the petitioner, the respondent number 7 and respondent number 8, my lord, who is illicitly living with her, my lord, has left for Varanasi. my lord.
How are we bothered about any illicit relationship? So only question before us is regarding custody of the child.
Yes, my lord.
Why we are trying to confuse the issues? You have also filed a questioning petition.
Yes, my lord.
What is the date in that?
My lord, notices have been issued in that, my lord, and subsequently it has not been listed.
Read page 83. Paramount interest is the importance is the best interest of the child.
Yes, my lord.
Read 164 of the child. It is referred to extensively. Why are you entitled to custody? Does your client? 83, you got it?
Yes, my
Does your
lord.
client
My lord.
anywhere indicate such conduct which entitles her to the custody of the child? Read please,
My lord,
second and third para.
my lord, I have read, my lord.
Then
My lord will see. But the entire maneuver has been done
paramount
by.
importance is the welfare of the child. So welfare of the child, can it be said that you have done anything to earn that right to have the custody?
My lord, with due respect, lordship, my lord. My lord, for 2
The
years.
child was with you when she gave the statement. She was not under the influence of anyone else.
Lord, that is how.
As a matter of fact, the offense is applied. We'll call the 482
Yes,
petition here also.
my lord,
We'll decide that
yes, my
here
lord.
only.
My lord, we are before your lordship, my lords.
Yes.
My lord, in
And
fact,
438 you have been granted. We
My-
are very sorry to say why it has been allowed.
my lord will see in the case diary, there was not even the my lord, medical report, my lord.
Not required, sir.
My lord, now they have,
Not
my
required.
lord, now in the charge sheet, they say
Absolutely not
it's-
required.
it's a simple injury, my lord.
Oh, injury caused to
Understood that.
11 years child.
So that is, my lord, whether it's been caused or not, my lord. My lord will see.
That is, the child says it has been caused means it has been caused. We are really sorry to say that why the lady was granted anticipatory bail. There was no case at all. What do you say in light of 164? Read the provisions of JJ Act. JJ Act then.
My lord, just permit me to indicate.
We may even rather than sending her to the mother, we would have been persuaded to send her to the institution had the other natural guardian not been there. Read.
So there has to be decision on that aspect, my lord. That has not been done.
Decision is there. The 164 statement will be ignored.
My
Will
lord,
be ignored.
in what circumstances that statement has been made, my lord, that
You
has
let
to
us
be-
know. You tell us what were the
So
circumstances.
what has happened, my lord? In 2021, my lord, the husband files a divorce petition and custody while living in Calcutta, my lord. He suddenly disappears. And my lord, the petitioner's daughter is a serious pancreatic patient, my lord. For 2 years, she has been,
Why would she state such strong words, strong allegations against her mother? Tell us.
yes, I'm coming to that. my
Yes,
lord.
please.
Even in 2021, my lord, an FIR was lodged in Dibrugarh, my lord, by the
Yes.
husband. The police had inquired in the matter. She had made statement and that has not been recorded. In Kolkata, my lord, there is an FIR where the husband has uploaded the video of the petitioner's daughter, my lord, making allegations against her. She has been tutored, my lord. During the,
Where was the occasion for the husband to come in touch with the daughter, Mr.?
my lord, immediately before the proceeding before the apex court, my lord, she has been living with, my lord, the petitioner has allowed her, my lord, for visiting right. And she was there for 5 days with the respondent number 7.
On what date?
In April, my lord,
April. And when was the statement recorded? sir?
12/5.
So there was a gap of 1 month. She was with you. Unless the child was in distress, she would never have given that statement. We are not entitled. All right, argue. Services complete, argue on merits.
I will kindly see the
You've seen
164,
everything.
164 statements, my lord.
Is there
My lord,
part of the order by which you have been granted bail?
my lord, who has granted her the custody, my lord?
Forget about it. We will confirm that fact that custody has rightly been granted. Even it was initially illegal. The paramount consideration is the welfare of the minor. And that has been taken care of.
My lord will permit me to place one angle, my lord. Even in
Yes.
there was a settlement agreement before the apex court, my lord, that we have.
We are absolutely not persuaded by whatever agreement there have been in between the parties. Question here is what the child says. There is no reason to disbelieve that. Absolutely. You tell us one reason why should we disbelieve the version of the child.
My lord,
And then there is an observation. It was a distress call to the CWC.
my lord,
Then the entire scenario.
my lord, there is nothing on record, my lord, as regard the, my lord will see how respondent number 7 has maneuvered the entire thing, my lord.
Oh.
My lord, even it
The
is,
statement of the child was recorded at the instance of the respondent number 7.
yes, ma'am.
Oh, tell us from what material do you say so?
My lord, she has been influenced, my lord.
Oh.
My lord will see in the recording before,
Precise dates when she was with the father. Let us-
my lord.
Everyone is in the influence of the father, the school authorities, the CWC, a child, everyone. That's right. So, all right, the father has so much of influence that the child can state against the mother. Then the father has some kind of love and affection for the child.
My lord,
Otherwise, he would
my
not
lord,
be
this
persuaded.
is very unfortunate situation we are in, my lord. It's not, my lord.
Unfortunate that a mother treats the child to such
No, my lord, with due respect, my lord.
absolute inhuman treatment, inhuman behavior.
My lord, in fact, she was when operated in Hyderabad, my lord, in AIG, my lord, her father did not visit. Also,
Mr. Fresh settlements.
In fact, my lord, the public private partnership,
Where are the IAs?
I number 2220 and 2205.
I filed an.
What are you saying, Mr. Rama?
Yes, I have filed affidavit as per last date instruction lordship.
You file affidavit in writ petition.
And yes, writ appeal regarding not regarding stating the settlement to be given to all the.
All right.
Then
That
one
you
bill
brought up
lordship
record.
on one of the settlement holder refused to take. In one of the cases, we have issued, but he refused to take. I have given the copy of.
Yes, my lord, today they have served.
He refused to take it.
Refused to take it. And second bidder also we gave, he also refused to take. Then again, we should press NIT lots.
Fresh NIT is required.
In fact, my lord, we have also filed a contempt petition. Your lordship has been pleased to issue notice. There was an interim order not to give the settlement. In spite of that, my lord, the settlement has been given. That is in my lord, item number 14, my lord. Now that will come, my lord, I think.
IA number 2220 is there, no?
Yes, my lord.
Impediment.
Yes, my lord.
IA number 2220/23 issue notice to the respondents. Standing counsel, Mr. So appears for the response numbers
They'll appear for my lord 1,
1, 2,
3,
1, 2,
4,
3, and 4.
and 5, my lord.
As process be issued to
2,
4
3,
and
4,
5.
5. 2, 3,
Thus
4.
process be issued to the
Response number 1. I mean, this opposite party number 1, my lord.
where is the cost title, sir?
So protocol.
For first title, my lord, page 1 and 2, my lord, 2 and 3. Then, my lord, page 4, your lordship, serial number 1, the opposite party.
Dharani Das.
My lord,
Dharani Das is the party.
Subroto Sarkar, my lord.
No, it was another case, Lord. This was both.
Number
Writ
number 1.
IA number 2220. ये देना सुब्रतो सरकार. Yes, it.
Subroto Sarkar is the person, my lord, settlement holder.
But his name is not there in the array.
No, it is not.
That is what the problem is.
Will be arranged, my lord, that this is the prayer for it,
Issue notice to the
my lord.
respond number 1, Subrata Sarkar.
My lord.
Rule is made returnable in. The party sought to be impleted. That is Subrata Sarkar. Rule is made returnable in 4 weeks. Is any other parties also?
No, my lord, there is another IA, 2205.
2205 ki देना.
That is another retaping 349. There, my lord, the
Subrata Sarkar has refused.
No.
IA number so and so issue notice to the newly impleted respondent Rahul Das.
Rakhal Sundar Das.
Respondent sought to be impleted
Rakhal Sundar Das.
Rakhal Chandra Das.
Right.
Respondent number 1 in this application. Rule is returnable in 4 weeks. Steps for service will be taken in 3 days, whereafter process be issued. Do you need Dasti service, sir?
My lord.
Dasti service is required.
Dasti Kurba.
Dasti service. Baki service along with it.
In 8169 Lordship, in 8169 WBC,
Yes.
I have given the copy Lordship, but there is nobody has taken up Lordship.
Copy 2,
Regarding
8169, you have given it to the appellant's counsel. Petitioner
There is status of the bill Lordship. Status of the bill Lordship.
status.
My lord, in item 15, my lord, we had earlier taken steps upon the respondent number 4, my lord. On 28th of June, as on date, no one has appeared, my lord. Otherwise, we will take steps to Dusty, my lord.
Item number.
Item number 15, my lord.
Issue
One
fresh
page.
notice to the unserved respondent. Steps for service be taken in 3 days, whereafter process be issued. Rule is made returnable in 4 weeks. Thus the service is permitted.
Yes, my lord.
Item number 16.
But in this case, as said, the judgment of the Honorable Single Judge, page 176. But the issue, my lord, just in short, my lord, in Assam Khadi Board, my lord, there is no service rules. They made one service rule, but that was not approved by the government, my lord. So government given one instruction guidelines for promotion, my lord. The UDA senior assistant superintendent. Class 2 contains superintendent. Here in this case, what has happened? The EDA has been promoted to the post of superintendent, and that assistant superintendent one jumped, my lord. That's what. But the system is since like 40 years in the Khadi Board is, my lord, from the LDA to UDA, UDA to assistant superintendent, so assistant superintendent to superintendent, my lord. Here in this case, from the UDA, state is going to superintendent, my lord.
EDA. UDA.
UDA.
UDA to superintendent.
Yes, in between there is one post, assistant superintendent, my lord, under class 3.
So what they have done?
My lord, they have promoted the petitioner from the post of UDA to the superintendent, my lord.
And
When
you,
this,
you are
yes,
appearing for
I'm waiting for the Khadi board, my lord.
Khadi board.
Yes, yes. In
And
fact,
who has undertaken that exercise?
the board, my lord, board has done it, but at that time it was not a board. That's true. It was, that's I understood, my lord.
You're
It was
challenging your
when-
own action.
Yes, when this matter came to the notice of the complaint to the
So
chairman.
basically, you are complaining of a self-inflicted injury.
Self-complaint.
Self-inflicted injury.
Exactly, my lord.
So
That's
what is the remedy?
my lord. Remedy.
Yourself.
I'm just saying, my lord. I'm
Yes.
just submitting. When this matter came to the notice of the chairman, because he was not aware about chairman. He can notice, he received a complaint, then he said, "Order, let us re-examine the matter. How come this has happened, my lord?" And the order of promotion may be kept in abeyance. Against the order, my lord, it was challenged to the writ court, my lord, and the honorable single judge passed the order, page 176, my lord.
Yes.
And operative part is 188, my lord. Kindly come to page 188.
Para,
It's in the middle, my lord, in the middle.
para.
Para 11.
Yes.
Yes. 188, my lord, in the middle, my lord, let me get. In the category of posts shown in the said communication dated for
Section 30, the board is empowered to make regulations governing service conditions.
yes.
So the board has taken a decision. Can the chairman override that, overrule that decision?
My lord, it's not the board. Board constitutes also the chairman. Here that it
He's
came
one
up
of
to the
one of the components.
yes, it came up to the CEO, chief executive member, my lord, my lord. Up to came. It didn't reach up to the level of the my lord chairman, my lord. When the complaint was lodged by other employees, see, this is what is in the office. Because last 40 years, people are being promoted from UDA to assistant superintendent, then to the superintendent.
Come to communication dated 4/11/88, wherein superintendent, assistant superintendent and UDA
Yes.
are shown as class 3 posts.
Page 52, that guidelines. Please come to page 52, my lord. Not
What
52.
do you say to this finding at page last part of para 11 at page 13 of the judgment?
Yes, my lord, let me just read it once.
Yes.
In the category of posts shown in the said communication dated 4/11/88, issued from the office of the Deputy Secretary, Assam, Government of Assam, Handloom Textile, Secretary such and such, amongst the class 2 posts, superintendent is shown as one of the posts. So for the class 3 post of concern, assistant superintendent and UD are shown as class 3 posts.
Yes.
It is not in dispute that pursuant to the communication, all the service rules were visited, same way are never approved by the board. That's true. Now, my lord, please, I'm explaining, and my lord, come to page number 51, my lord. That's instruction, my lord. Page 51. Lord, you kindly see class 2 post bottom, my lord. Register, statistical officer, development officer, superintendent, my lord. At the right side B, for promotion, minimum graduation in any discipline or having certificate from recognized institution or technical qualification wherever necessary, and minimum 5 years service experience in feeder post.
cadre.
Feeder
Feeder
post.
post, yes.
Yes. Now come to the next page. Next page, my lord.
You are arguing, sir, that there is an intermediary post of assistant superintendent.
Yes.
Read that page.
Next page, my
Where
lord.
is it? The intermediary post. Yes, we are on that.
Yes, my lord.
Page 52.
Next page also, my lord. Assistant class 3 post. Assistant superintendent, UDA,
And UDA.
LDA.
We are concerned with the promotion of UDA to superintendent.
Yes, yes, that is it.
Assistant superintendent and UDA are placed in the same
Yes.
level.
There my submission will be.
Yes.
Even LDA is also placed in the same thing, my lord.
Maybe.
Now, can the LDA say that you promote me to the post of
No,
superintendent?
that is a mess created by you yourself.
But
Who
that
is not-
system is in PBL listing of 40 years, my lord. 40 years it is in PBL, my lord, my lord.
You create a proper channel of promotion. What is the problem? Now here the writ petition has been promoted and the rules permit such promotion. What is the problem?
Rule is not clear here. My lord did not say that from the post of superintendent UDA to superintendent. Rule doesn't say so.
Feeder cadre is shown as class 3. And in class 3, assistant superintendent, UDA, LDA, they are all placed.
In that case, my lord, LD is also coming in 3, my lord.
Yes,
Whether
it
LD is
will come,
permissible to go to the post of superintendent, my lord.
It will go,
I
it
don't
will
think
go. You
that-
clarify things. Wherefrom we read this part that UDA will be promoted. Where are the pay scales?
My lord,
Where are the pay scales?
pay scales both the same, but only
That
grade
is
pay
the
is
governing
different.
factor, sir. That
Yes.
is the governing factor.
This is in last 40 years, the first case it happened, my lord.
Gentlemen, if the pay scales are same, in your list, the cadre 3 posts, the group 3 posts, the nomenclature contains both. then how can we read that assistant superintendent is a promotional post from amongst the cadre 3 candidates?
My lord, if this, my 100% I agree to you, but if this principle you accept, in that case, the LD will come and say, all right, I am in class 3, put me in post of superintendent, my lord.
Let us see the pay scale. Perhaps pay
Yes.
scale would be governing.
Yes, pay scale. My lord, page number, lordship, may please come to page number 137. 137.
Yes, you have an opportunity to rectify. The judgment is there. That should be a guideline.
I think.
That should be a guideline. The
This-
slumber of 40 years. Now you should wake from that.
I 100% I agree with your lordship,
Sir,
my lord.
that's all.
My lord,
Advise
kindly come to
accordingly.
page number 137, kindly see the scale.
Yes.
For serial number 3, my learned friends
Pay
client.
scales as per the posts, not of the person what they are drawing.
This is 8,000 and
What
My
is the
lord.
pay scale of LDA?
yes, now please come to page number 137, 143, my lord. 143. In the middle, lordship will find, my lord. In the middle.
Is there any structured chart of pay scale?
No,
please?
that is not there. That is they have given as per the ROP. In the middle, my lord, pay scale, page 143, in the middle. Pay scale of assistant superintendent 8,30500. Grade pay 4,300.
Same.
Yes,
Where-
same.
Sir, you were arguing that LDA will also claim promotion. What is the pay scale of
No,
LDA?
There is a lower. No,
That is the governing factor, sir.
my lord, the principle, the way, my lord, the judgment doesn't reflect that, my lord. That's why my, yes, my lord. I understood. Pay scale is same. I told my learned pen. See, the scale is same. Now, this is what.
Right, scale is same, grade is same in your own list. Then what else is the governing factor? Where is the decision of the board? Let us see, of promoting the.
Yes, my lord. Lordship will find it that board promotion, my lord.
149 is the minus.
Yes, 149 to 151.
151.
Sorry, my lord, 132 is the minus. First promotion.
DPC
Commercial,
20th
yes.
March 20.
And before that, please come to page 104.
Sir, just a minute, just a minute.
Second paragraph.
কাগজ to be clear কাগজ to. এই যে নিজে সাইন করে দিয়েছে।
Second para.
Lordship. As per this committee, that is in terms of the my lord, comment guideline dated 4/11/1988 and passed the following recommendation. So they went by that 51 page 51 recommendation.
But where is the exact resolution
My
to
lord,
promote?
it's 134.
134.
Oh, 34 top, my lord. Superintendent.
Yunu Mansa, how many have been, one has been promoted?
No, my
Only,
lord, all these 4 were recommended.
all 4.
My promotion was to be on
Printed, yeah,
retirement
printed,
of
yeah.
serial number 2. So when serial number 2 retired, I got it.
Okay,
In my lord, one thing, my lord.
yes, please.
Please come to page number 103.
Just a moment, sir.
103. How it came, my lord.
Just a moment. Now, where is the decision to recall this?
My lord, recall, my lord, that's in page number, my lord. Kept in
And
page number
just-
152.
Just Nair,
Lordship.
recommendation is only for Manalisa Deka.
No,
Not the other.
recommendation is for all the 4. And Mona Lisa Deka will be.
No, it's only for 2.
No, no, no,
Recommended so and so, yes. So what
Committee
about the
recommends
others?
no, no. My lord, we'll see the first line. The committee has
has
recommended the
recommended
following
following,
promotion to the post of
uh,
superintendent.
Hemen Mehta has been
Rejected.
rejected on account of.
And
adverse
Mona
remark.
Lisa Deka 2 is recommended a promotion subject to retirement of Dipali Deka.
Yes,
So when Dipali Deka retired, my lord, the promotion order came in 137. my lord.
and where is the review of this decision?
Review of the decision.
My
my
lord,
lord,
page
is
142.
140,
Yes.
yes, 142,
And
relevant
149.
143.
It is by the board. or
It's
by
by
the
a
chair?
committee constituted by the chairman.
Okay, and what is the composition of the board?
My lord, the board composition.
members.
5 members would be there.
Page 142.
No, board.
Subsequently, my lord came to
Deputy Director, CEO, and Deputy Secretary.
Lordship.
That is the board. And who are the committee members?
My lord, this is the committee members, my lord, at
Chief
Page
Accounts Officer. So
142.
they can supersede the decision of the board. Where are the relevant rules giving power to the board?
No rules,
No rules at all.
nothing. And
that's not
143,
handicap bracket.
their only case is, my lord, that promotion should be to assistant superintendent, then to superintendent. My lord, it has been revealed that there is no such rule available.
And there's a chart of feeder post, my lord. Lordship, kindly have a look once, my lord. I want to show one thing. Please come to page number 103, my lord.
Where from was it
See
prepared, sir?
how it came.
Where from this 103 was prepared when you have a pay scale, proper pay scale, which has been laid out in the document you showed us.
My lord, pay scale, they rely on ROP rules, my lord. There is nothing in the service code, my lord.
There
But
is
please,
no-
please, I just want to show one thing. Please come to page 103, my lord.
Yes,
Just
please.
Can you see?
103.
He had decided in the Department of Promotion Committee held on 21/12/18, a committee has been formed consisting of the following members to re-examine, my lord. The committee shall be such. Kindly see the names of the committee, my lord. 1, 2, 3, 4, 5 persons. Out of the 5 persons, 3 persons, one is the petitioner and 2 other her colleagues, my lord. They what out of these 5, next page, kindly come to page number 80, my lord. 104, next page. Kindly see, 3 of them has made this list, my lord. Statement. Only 3 of them made the list. And they are produced before the Department of Promotion Committee, not others. The beneficiary, the 3 persons, they made the list. It is their signature, my lord. Clear signature is there, my lord. On their recommendation, self-recommendation, my lord, promotion was made, my lord.
Do you have anything to the contrary as against the position of the feeder cadre for the promotion to the post of superintendent?
My lord,
Any contradictory material with you that this is not the feeder cadre? UDA is not a feeder cadre.
my lord,
Go by pay scale, go by any other standard.
my lord, except that example of last 40 years, repeatedly they promoted from that, otherwise nothing, my lord.
May have done it.
My lord,
That
otherwise
was a
nothing.
wrong practice which was being
I
followed.
concede to
We
this, my lord.
can't approve such wrong practice. Yes, Mrs. Nair.
Manoj, they made a rule. They circulated it amongst us, and there was something. But my lord, finally, when we were trying to implement that, say that rule should be implemented, in the WS, they say that is a half-baked one. Board has not approved.
Yes.
So we will go by the 88 government directions. And government directions, my lord, would find,
Where is that decision to follow the comment direction?
my lord, that in the 132, my lord would find it. My lord. The DPC's second paragraph, my lord. The committee, second paragraph at 132, examine the panel placed by the office for promotion in different grades and discussed on various aspects like seniority, performance, up-to-date ACR, and also roster point 113. Government guidelines dated 4/11/88 and passed the following.
The government guidelines are at
Page 51, my lord.
Page 51, yes.
Now what they have done, my lord. Here, my lord would find registrar, statisticalization development superintendent, and then my lord comes down publicity officer and planning officer. So the persons, other 2 persons who were promoted along with me, and this were kept in abeyance. Subsequently, what they did, my lord, retrospectively, they have promoted them to publicity officer and planning officer, whereas my thing was kept in abeyance. Then I approached this honorable.
Okay, very well.
And the honorable single judge has said exactly that you don't have a rule, you follow 411, and if it 411 is followed, then this is the consequence. And she is retiring in October.
Okay. Arguments heard or reserved.
My lord, I thought the person who has got long height will jump, my lord, in the Olympic, not in the department, my lord. My learned friends, look at the height, my lord, at the jump.
The jump has been provided by your department.
Department itself.
The launch pad was your own department.
I know, my lord. That's true. Oblige, my lord.
Item number 17.
May I please lordship. My lord, in the year 1962, 7 biga 4 kata, 17 acres of land were acquired for construction of 4-line national highway.
Yes.
Thereafter, my lord, some process were made by the government, National Highway Authority, as well as the present petitioners, that they would pay the compensation. And they started paying compensation to various persons. Last payment they made to one Manullah Sheikh in the year 2008. At that time, we were very much surprised that because though the land were acquired in the year 1962, but last payment has been made in the year 2008. Then we approached the authority to why our compensations are not paid. Then they started further process, and finally till the year 2013-14, My lord, they are communicating with each other. Everybody is saying they should be paid. They should be paid, including National Highway. My lord. Now, but only this interdepartmental communications are going on that compensation should be given as per present market value to the affected persons. But ultimately, nothing was paid. So in the year 2015, we filed a writ petition. The learned single judge first time payment order paid 100. Your lordship would see the main ground for which the learned single judge dismissed our writ petition, that lordship, page 106, kindly see, that is 106, my lord.
Delay.
Delay, only point of delay. Now we have provided, my lord, 17 judgments of the Honorable Appeals Court.
Admission notice.
Okay.
Steps for this service be effected by supplying copies of the writ appeal to the standing council concerned. Recognize the right to the compensation of the people. Yes.
Item number,
Mention the ministry.
If your lordships observe, we have no objection. But your lordship observation must be there because everybody is ready to pay.
Acquisition by the PWD.
But the landed single judge is not ready to pay. Only on the ground of delay, which is
It's not on that, Mr. Council. Right now, the issue is where he says that you at least make the department clear. And council for the appellant shall make the necessary rectification.
no, that is clarified letter.
Which department?
No, it is corrected letter. Indian Minister of Transport, and that is corrected. That is corrected. Our lordship may kindly see, it is corrected. As it was in the writ
Now that is
petition.
there. The copy, maybe you have not given the proper copy.
Yes.
NHI also is there. List for hearing in due course.
item number 18.
Yes, what is the matter about?
It is with regard to, my lord, on account of holding the national games, 33rd national games in the year 2005. The petitioner's plot of land, my lord, it was damaged. And it was damaged, my lord, by the National Games Authority for, my lord, conducting the event of rowing. Now, the fact remains, my lord, that before the learned single judge, my lord, an affidavit was filed by the deputy commissioner, my lord, where it has been specifically pleaded that the petitioner's plot of land was contiguous, my lord, to the plot of land which were acquired for the purpose of holding the event of rowing. My lord, in the process of digging out that land, petitioner's land also happened to be dug out, my lord. That is how the matter rests. And my lord, the learned single judge, my lord, had directed the revenue department as well as the deputy commissioner to make an assessment, my lord, and my lord,
Pay the compensation.
yes, pay compensation. It was, my lord, twofold direction, either, my lord, alternative land or compensation. Then, my lord, the authorities, my lord, we have filed an appeal, my lord, assailing the decision.
What is wrong in the decision?
Now, my lord, there is
an admitted position.
My lord will kindly consider, my lord, there is no negligence. What is the issue of negligence on our part?
Then it happened by, what was it? It was act of God or what?
No, my lord, it was done by some other, anyway, my lord. Now,
That's not your case, sir.
Yes, now.
Contiguous plot, if you undertake some activity, obviously, the effect might come on the, a reasonable suspicion arises that the effect may have.
I bow down, my lord. Now, lordship will kindly appreciate by a flux of time, my lord. Now, matter has come to such a position that this honorable court, in fact, your lordship was pleased to direct, my lord, the authorities to give, to make an, my lord, survey of the plot of land. And, my lord, if possible, my lord, to provide alternative land or compensation to the petitioner, my lord. Accordingly, my lord, the survey was conducted.
Yes.
Yes.
So 11, that order is already passed on 25/7/22.
Yes, my lord, and survey was conducted and it was found that the total quantum of land which the petitioner owned, my lord, it was 2 kotha 10 lesa. Out of 2 kotha 10 lesa, my lord, 1 quota 10 lesser of land, my lord, more than half of the land, my lord, it was found to be, my lord, inhabitable. Rest 1 quota was found to be habitable. So therefore, my lord, the authorities, my lord, convened a SDLSC meeting, my lord, whereby, my lord, an alternative plot of land nearby to that petitioner's original plot of land was allotted. Now,
It has been allotted,
yes, it has been allotted.
but the
Subject-
issue is of the size.
Issue is, my lord, now he has filed an affidavit, my lord, complaining that, my lord, that alternative plot of land is not, my lord,
Not habitable.
not habitable, not feasible to him.
Then what is your response to that?
Now, my lord, I have to take instructions, my lord, since this affidavit has come, my lord, little late.
The standing council, Bor Pujari, raised for it is granted. 4 weeks time to take instructions regarding averments made in the additional affidavit in opposition filed by the respondent number 1
My lord.
on 17/7/2023.
My lord, my
Next, up 4 weeks.
lord.
Top of the list matter, item number 1.
What happened to the item number 19? Okay, that has been adjourned. These matters seem to have been listed wrongly, as a matter of fact. They are not in this category. So if you want to argue the same right now, we are ready to hear. Otherwise, they can be taken up subsequently. It's your choice.
Some other date, my lord, let me, my lord, go through, because, my lord, your lordship thought some instructions, yeah. We could get only few only.
All right.
In fact, it was listed day before yesterday.
We know. The category is wrong, but otherwise we had posted it today.
My lord.
You're right. The additional payment for the
That's
judgment,
true.
any trade in
Exactly.
holding.
Exactly.
That is the issue. Yes.
Issue is, my lord, their claim is of 1 crore 71 lakhs and all that for the, my lord, additional distance.
Yes.
That is the case, my lord. We say that this, the Anup Trade, Food Corporation versus Anup Trade applies. Or this.
They say any trade applies.
That is the issue, my lord. Your lordship,
Limited of that only.
your lordship can decide in, huh? Yeah. On that count, my lord, may decide.
Very well then. Yes, what do you say, Mr. Tekam?
My lord.
Which judgment applies, that is the only thing which is to be seen.
Yes. My lord, prior to that, my lord, just few documents I'd like to show, my
Very well.
My lord.
This fact is not disputed that the distance was
Exactly, my lord.
their own committee was there.
Exactly. So I'm not going into that aspect of the matter.
Yes.
So, my lord, what they are.
Before he points out, I would like to point out one thing, my lord.
Yes,
Lordship, can you just, I'm just, my lord, not on that, my lord. What happened, my lord, my lord, 232 kilometer by the distance, tender was called for. He submitted a tender. He quoted the rate from one place to another place. My lord,
What
he
you had indicated in your
Yes.
tender document.
My lord, I have shown that, my lord, page 81, that, my lord. And, my lord, 49 capital A is the page, my lord, where, my lord, your lordship will find that, my lord, when we issue the work order, page 49A.
So, Mr. Agarwal, this has been happening in so many matters that your authorities do not indicate the correct distance. When the transporter goes to the site, then it is revealed that, as a matter of fact, the distance is much more than what was projected in your NIT.
My lord, what happened in this case?
And you have already created a redressal system. That committee you have constituted, committee has given a report that distance is more.
No, that's true, my lord. My lord, I can't, my lord, go beyond that, my lord.
Then
I have to
what is
be,
your
my lord, I
argument
have to
then?
go by the committee report. My lord.
Then
That's true, my lord.
Then what is the argument?
My lord, my argument will be, my lord, that, my lord, since he quoted the rate.
He quoted the rate, but he quoted the rate on the basis of what you told him in the document. But when he went to the spot, he found that the distance is more, which fact you admit.
No, that fact is admitted.
Then-
No, Lord, I can't deny, my lord.
Simple.
I can't deny.
It's a layman's calculation.
I
that
can't deny.
You sold an item saying that it is 1 kg. All right, he paid a rate for 1 kg. But then when ultimately you found out that the item was 2 kgs and you are now asking for a rate of 2 kg, what is wrong in it? You enjoyed the benefit of having transportation for 50 kilometers excess. So how can you charge him?
My only argument before my lord.
Yes.
My lord, is that, my lord, that since he quoted the rate from one distance to another place, and he accepted it, my lord.
What
My lord, then in
you
that
qualified that distance to a certain number of kilometers.
That in
Which
tender
factually
document,
was wrong.
tender document 232. That was
So
wrong.
which factually was wrong.
That was wrong.
He was not having the facility of Google Maps. And otherwise also, you see, it makes a hell of a difference. Aerial distance, road distance, route which is pointed out. So he is not supposed to go and chart out the kilometers before quoting the rates.
Under the contract, my lord, they are, my lord.
But
Anyway, my lord,
you-
I leave to my lord, my lord.
All
I leave to my.
Yes, no, please.
My lord. My lord, what the distinction they are trying to bring in, my lord, between two bidders, one who has quoted per kilometer per metric ton basis.
You had quoted per metric ton only.
I had quoted per metric ton.
So
my
then
lord.
they distributed it into per metric ton per kilometer.
But that is exactly as per the tender clause, my lord, page 46.
They converted it.
They converted, they are required to convert it, my lord.
Yes.
Just below the table, my lord. NB
Per
and-
metric ton per kilometer, then actual kilometers has to be counted.
Exactly.
That is what I'm.
As per the rate quoted must be as per metric ton per kilometer. Lordship has got it.
Where are you reading?
Just
Yes.
below the table, my lord, NB and thereafter.
Yeah, it will be converted.
The rate should be quoted as per metric ton per kilometer as per, if rate is quoted otherwise, which I have done, my lord, it shall be converted to per metric ton per kilometer, taking distance as mentioned above. So I have quoted 2759, they have divided it by 232, they have arrived at a particular kilometer rate, my lord, and the honorable single judge has permitted only that, my lord. That admittedly distance is 50 kilometers more, so you pay at this rate, my lord.
Okay, but
Now
what about their argument that under the contract, it was specifically mentioned, you should have verified what is the exact distance.
That has been
before
dealt with in that any division bench judgment, my lord.
Okay. And what is the difference in the that judgment?
No, because why I am telling, my lord, in that judgment, ultimately the direction passed is that matter should go to the GRC. Now I'll place before your lordship the stand taken by the FCI, my lord, in this particular case, my lord. Lordship will kindly turn to page 81, my lord. 80. This is the affidavit file.
80.
This is against my pleading that it is pending before. Lordship will kindly come to page 81.
Yes.
In bold, it is written, my lord. The said application is pending before the grievance redressal cell. Then we read further, my lord. It may be stated here that in case of another road transport contract, the contractor so-and-so had submitted a representation to this zonal grievance redressal cell. The said representation was also regarding increase in distance for the contract so-and-so to so-and-so. The said contractor had quoted in the price rate of so-and-so per metric ton for the entire distance. And in the said NIT of the respondent, it was mentioned that the rate should be quoted as per metric ton per kilometer, as per MTF. Same clause, madam. And if the same is quoted, otherwise it should be converted. The claim of the transport contractor for payment due to change in distance was rejected on the following law. So, my lord, the GRC has already taken a call, my lord.
Taken a decision.
So now sending me back, my lord, it will amount to a post-decisional hearing, nothing else. And this is not brought to the notice of the division bench while deciding on a.
Is this decision on record of the GRC? No.
No. But this is on affidavit. They are saying that
Are they referring to the dismissal of the claim of the
Purvanchal, not Anupted. It could not have been Anupted, my lord, because the affidavit is filed in March and the Anupted judgment is in February, my lord. And my lord, they have not even produced the result of the Anupted's case before your lordship's, my lord. Not even a single claim, my lord.
Where is the judgment in Anupted?
Anupted judgment, my lord.
Page 144. 144.
My lord, ultimately the judgment, the operative portion, my lord, lordship will find at page 155, my lord. Because lordship sees there are, my lord, there are three distinct stands taken by the respondent, my lord. I mean the appellants, my lord. In this case, Anupted, they say that there is a calculation required. In my case, my lord, there is an absolute denial that you are not entitled. Whereas in any trade, my lord, a separate calculation is sought to be made, my lord. Paragraph 16, my lord. So far as calculation of the rate is concerned, because the rate quoted by the contractor was not per metric ton per kilometer in the considered opinion of the court.
In Anupted, the decision is based that you go to the grievance redressal committee. So there is no decision as such on merits.
No.
And wherein any trade, Where is the judgment?
My lord, if your lordship sees the single judge's judgment, my lord, page 71, my lord.
Where is the any trade judgment division bench?
Division bench starts is at page 123. But if your lordship kindly peruses 72, my lord,
Yes.
of the single bench judgment, my lord,
In any trade or
in
this?
any trade, my lord.
72.
72, my lord.
Yes.
Here, my lord, this everything will be clear. I'm reading, my lord. Para 14. The L2 tenderer had quoted rupees 2799 for the distance of 243 kilometers. And based on the same, the rate of 11.52 per metric ton per kilometer was arrived at by the respondent authorities. The petitioner had quoted 11.41 per metric ton per kilometer, and thus he has emerged as the L1 tenderer. However, the respondents have now taken the said rate of 2799 to be the rate offered by the L2 tenderer for the entire distance of 295, which is not the case. Same principle they are trying to apply here, my lord. The NIT itself made it very clear that the rate per metric ton shall be as per the MTF, and if the rate quoted is otherwise, rate per metric ton will be worked out taking the distance as notified in the NIT, which is 243 kilometers. In fact, in this factual background, the exercise undertaken by the respondents to find out as to what would have been the L2 bidder for per metric ton per kilometer by dividing 279 by 295 is arbitrary, irrational, and
That
defies
was
all
a
logic.
case wherein there was a conflict whether L2 should be given or L1 should be given.
Whether L2 rate should be given.
Rate should be given.
Work was completed there also.
Work was completed.
Because in principle, my lord, they decide that any trade should be paid as per the actual distance, my lord. Now, why the
in the present case, where is the finding regarding distance being more than what was quoted?
My lord, finding in the judgment or my
their finding?
Their finding. It is at page 55. My lord, any trade and my case, my lord, arises out of the same NIT.
Same NIT.
Same.
Then what's that?
Same report, my lord, page 55. There is a table, my lord. Any trade is the first table, and my case is the second table.
Same NIT, one judgment, the other judgment can't be inconsistent.
Same NIT,
And the stand
five different places, routes were there from the Salsapara.
How a different view can be taken. And that Anup trade, the only observation of single, the division benches go to the grievance.
No, not on this side. But not on the landed single judge judgment was not set aside in that case where the direction was given to make the payment.
Because the redressal had not been resorted to. Exactly. That is basically an alternative remedy. The matter was taken. Okay, very well. Dismiss.
All right.
I'm obliged.
Item number 3.
My lord, the private disputes between the parties now, my lord, they invoke writ jurisdiction, my lord. My lord, the facts of the case, lordship, I just want to net in.
This has been wrongly listed today. We'll hear it at leisure.
That's why we also survive. Otherwise,
that's an error committed by the office.
Lordship,
For hearing. The
lordship,
matter has already been
any date, my lord.
ordered to be listed for hearing in due course. Thus, the registry to comply and list the matter accordingly.
My
No,
lord,
dates, sir.
thing is that
That was the very intention. Thank you.
Lordship, may I only play one thing? Lordship, may fix any date, my any
No date required.
date.
Thank you.
Item number 5.
Starting my understand, fix the matter on any other date.
So this matter was already ordered to be listed for. This matter has been, the appeal has been admitted. Thus, list for hearing in due course.
Obliged.
For hearing, item 24.
What is this, Mr. KL?
It is Central Access appeal by the department against the order dated 1/12/2017. Two questions were framed.
Is the respondent? None present for the respondent. List up 3 weeks for hearing.
Item number 25.
What is the evidence, Madam Public Prosecutor?
Yes, Lord.
Yes, based on direct or circumstantial evidence?
This one, Vijay Gwala, perhaps, yes, circumstantial. Now, what had happened is.
Circumstantial evidence, we have found your cases to be pathetic. 24.
Yes, sir.
Absolutely, yes.
In fact, the scooty was found in his possession. The deceased found missing. And he left with
Scooty of the
scooty.
deceased.
Yes, he left in the red color scooty. Thereafter, he was missing, he was searched, and then 2 days thereafter, his body was found and some injuries on the road and all. 23rd scooty was recovered from one of the witnesses' place.
So,
And yes,
witnesses place, how the accused is connected?
he went to his place, he stayed overnight. He went with that scooty.
Let us see who has said so.
This is PW. Mr. Pritam was there.
He's in like school.
Now let you say, Mr. Counsel. You are the Micas.
My lord, he's coming, my lord, he's in election, he's in election.
PW12.
Here, Madam John.
PW 12.
Can you read the finding of the learned session judge?
Yes, the circumstances are called out. Lordship will find it at internal page 13. Okay, paperwork.
Yes.
Internal page, I don't have the paperwork, unfortunately. Internal page 13 of the judgment, Lordship will see the circumstances. Few of them only.
Para 51.
Para 51.
Deven Burgoyne was the deceased.
Deven Borgohain, yes. On the day of occurrence, Deven Borgohain was riding a red color scooty. Next day, body was found recovered with 7 numbers of lacerated wounds. Accused had come to the house of Akim Chetia with that red color scooty and had stayed in the night.
Red colored scooty, did it have any registration number?
That is not true.
Can there be, is it possible that there is only one red colored scooty in the state of Assam? What is this?
Then this next circumstance,
Then
accused
extrajudicial confession.
Extrajudicial confession of
Kharia.
hiding it.
What did Ajit Kharia say? What did Ajit Kharia himself say?
Ajit Kharia said
Turned
that he,
hostile.
yes, no, PW 8.
What had happened, my lord, Ajit Kharia gave his 164 statement. Thereafter, my lord, before he could be produced before the trial,
he expired.
He expired.
How that statement is to be read?
Can you see the statement of Ajit Kharia, my lord, at page 77? He's the star witness. Page
He was
77.
not examined.
Page 77.
But I think section 133 will come in the evidence.
I'll show, my lord, that
Any statement.
32.
33.
Is it covered by 32?
32 is dying. 33, Lordship, that
The
any
previous statement of a witness can only be read in evidence if it relates to his cause of death.
33, I'm talking of 133.
Read 133.
133 is that previous statement made during any judicial proceeding will be used in the subsequent judicial proceeding if the person is dead, could not be found.
Not a judicial proceeding. This is investigation.
164.
It's not a judicial proceeding, madam. It's just a previous statement.
Previous
Go to 162.
No,
What is the use of 162,
Yes.
164? Either to contradict or confront.
corroborate, contradict.
Corroborate,
first,
contradict.
first kindly use the statement. What did Ajit Kharia say? my
Let's
lord?
see.
Page 78. May I read, my lords? On oath, my name and address are mentioned above. I'm 19 years old.
He had killed somebody.
My lords,
He had killed somebody.
my lordship would see the time and date, my lords. I know Kamini Borgohain, she resides in our village, but I know nothing about the death of the husband of Kamini Borgohain at about 6 p.m. about 5 days back. Lordship would see the date. It's dated 21/03/2015.
Yes.
And 5 days back would be 16th. The incident took place on 18/3/2015, my lord.
That is very,
And that has
very
been-
hyper-technical.
That has been corroborated by the magistrate who has taken the 164 statement. Lordship, kindly, if my lordship turns to
Ms. Manta, argue on substance.
My
This is
lord.
just the previous statement.
that is the only statement on which he's been convicted.
Have you got any judgment that this statement can't be utilized?
My lords, if I may kindly pray, my lord, if lordship takes it up on Friday, my lord.
No, absolutely no. No, every
criminal
day's
appeal-
detention, if we ultimately acquit the man, every day's detention is illegal.
My lord. Yeah. So criminal appeals are,
Are?
I've not argued many criminal appeals before, my lord. On Friday, my lord, I've come up with.
No, nothing.
Well, in that case, lordship would test the circumstances which has been stated by the learned session judge on in para 51, my lords, one by one.
We've read it already.
Yes, my lord. The second point, my lords, she says the learned session judge holds, my lord, the next day the dead body of the deceased.
313 admitted. 313 को wrong statement तो बोला ना.
313 अपना.
অসমীয়াত আছে নে?
No, 39. 39.
Yes, we have read it, all right. We'll decide the appeal.
Lordship.
But the statement of Ajit Khare is not reliable, my lord.
Mr. Mahanta, it can't be read in evidence.
Yes,
The
ma'am.
previous statement, plain and simple, read 162 CRPC.
162. Deeply.
It's not a statement which is otherwise, which can be read under 32. The previous statement can only be read in evidence if the person dies and it relates to the cause of his own death. That's all.
Dying declared.
Dying declaration.
Dying declaration.
But 133, if your lordship sees once, maybe.
133, all right. Let us see 130.
Lordship.
Evidence Act. Let us learn new law.
No, lordship cannot be a new law for your lordship.
Jahan.
But because cases are very weak here, I try to somehow bring it within the fold. 133 of the.
Accomplice.
Lordship.
133.
133 of the
33
evidence.
already.
Lordship.
33 also.
Hey, Lordship will
Yes,
see
33.
relevancy of certain evidence for proving.
Evidence given by a witness.
Huh.
So is 164 evidence, madam?
No.
Then
Evidence given by witness in a
judicial proceeding. So is 164 evidence?
No,
Evidence
no,
means
no.
substantive evidence.
No, not at all.
Evidence means substantive
Substantive
evidence.
evidence given during the trial. Yes.
In any judicial proceeding. Is
So 164 as such, I think, will not be included.
then how 33 comes
For
in?
Lordship, there is again an or. Or
Yes.
before any person authorized by law
Evidence.
to.
Evidence.
Evidence.
Evidence qualifies everything. So
Evidence.
commissioner,
Huh.
evidence given before a commissioner. Yes.
Relevant for the purpose of.
The magistrate general record police 34.
Law to take, it is relevant for the purpose of proving.
Adverse party in the first proceeding had the right and opportunity to cross-examine. These are the provisos which have to be followed before the previous statement can be read in evidence.
Exactly.
Adverse party in
You've
the
never-
first had the right and opportunity to cross-examine.
You have never.
It could not be he deceased dead.
Okay.
Because many such cases come, so somehow I try to bring it within the fold if at all it can help.
Okay,
But
very well.
difficult.
It's an exercise in futility.
Yeah.
Thank you.
Item number 26.
Before my lord, except 26, my lord, I was appearing in 24. My lord, 26, I think.
What was called out, no one came.
Was called
Now
out.
it has been adjourned.
My lord, can I pay for any date, my lord, because I am coming from Kolkata, my lord. Just that much of indulgence.
Take a date, whatever it suits you. Yes.
My lord, deeply obliged.
In September. What is the next one? What is the evidence?
Your lordship,
Yeah,
here the
eyewitnesses are
appellant,
there.
appellant has been convicted under 302. However, I'll try to pursue the lordship that even if the prosecution case is accepted.
304 thrown down.
Yes, your lordship. I would like-
Stabbing, knife stabbing or a rod, all right.
Rod.
Because he would come under 300 exception 4, I would. I would try
Eleven
to-
sudden provocation.
Yes, because the
Let's see.
entire PW2 and PW3 says that there was a quarrel between them. So they have, prosecution has not been able to establish that there has been premeditation.
Yeah,
Or,
let us see the statement.
yes, may I read PW2 and PW3, your lordship?
Yes, yes.
Your lordship will find PW2 at page 13.
And he's a neutral, he's a villager, co-village neutral.
This man is in custody ever since 2013.
Yes, he is.
No,
No, 2013, he was in bail.
on bail.
But I think,
Inside for
So
3 years.
even if it is 304 part 1, he goes 10 years.
yes, yeah, but I will try to again pursue the lordship. That will
Why
come-
it can't come to part 1, a part 2 in any event?
I will try. Injury, I will try to, just I'll try.
Okay, let's see.
Yes. Your lordship, page 30, page period 2, I know the accused, Neil so-and-so. The incident took place around 12 PM to 1 PM. At midday on that day, I went to look for a tractor and then I saw an ongoing quarrel between Bipul and the accused. I tried to dissuade them from quarreling. While I was trying to dissuade them from the quarreling, the accused tried to hit Bipul with an iron rod, but could not. Thereupon, the accused stabbed Bipul in his abdomen with an iron rod. So this iron rod, your lordship, is 3 feet 5 long. So I say stab means trying to hit it from a distance. It's not as if
Stab means poking it.
poking, your lordship. But his injury,
Which
your
is
lordship, see, it will be on the side, not on the front part. Anyway.
That depends on what kind of cross-examination you have made.
Yes. So your lordship, this is the part I'm relying to say that there was an ongoing quarrel. There is a sudden provocation without any fight, but prosecution has not been able to prove also who is the aggressor or who initiated the. So I was humbly submit that will come on the exception 4, your lordship. So again, your PW3, your lordship. I know the accused who is a fellow
She is
villager.
the sister.
Yes, your lordship. At about 1 PM, my brother Bipul went to a shop. My elder brother Bipul and the accused had an alteration on the road. Thereafter,
Now
I
you
saw
see, here your case goes out of purview of 304 part 1 for the reason he went to his home, brought back a rod and then hit him.
yes.
So now which famous judgment comes to mind?
But your lordship, he didn't hit it.
Yes.
But still, he didn't hit the vital part at the first instant, your lordship. He had hit it on the hand. So the intention was not to cause the injury on that part.
Let us see the medical evidence.
Yes, your lordship. May I go to period 5? On 24th, so I was working at Kanakara Civil Hospital, Tezpur, and held office on postmortem duty. And on that day, I performed a postmortem so-and-so. A male dead body rigor mortis present, midline surgical incision repaired, and suture material and BC flank wound present.
What is the date of incident?
Date of is 27. And
Just hold on. 27?
because he had undergone, your lordship, what is
20th July.
Yes,
And when did he expire?
24th. If I'm subject to corrections, 24th.
Date of incident is 20th July.
Yes, your lord.
After 4 days.
Yes,
Okay.
so that is also another point I will argue before lordship,
Three hospitals.
because there was many. So flank wounds present, the flank, your lordship, would be is a side of the body between the rib cage and the bone of the hip. So it's on the side, it's not on the front. So the intention of hitting on a vital part was missing, your lordship. And initially he had hit on the hand. Thereafter, while hitting, so we could not say with certainty that he had intended to hit in the vital organ of the accused or the victim rather. So, and your lordship, this last part is important, page 21. In my opinion, the cause of death of the person is probably due to pulmonary edema. That is the water being present in the lung. Your lord. But 24 will resume tourism.
Yes.
Your lordship, so why I would argue on the that it fall under part 2, your lordship. One was that the first hit was on the hand, second hit was on the side of the body. It was not, so intention to hit on that to inflict that particular injury cannot be said with certainty, your lordship, because it is on the side.
Yes. All right. Yes, madam.
To bring it within the fold of exception 4 or
First,
1,
you tell us, madam,
Lordship.
on what evidence do you show, do you say that the incident of 20th July was the one wherein he received the fatal injury? Where is the interlinking evidence?
Because 20th, after the injuries, he was
Yes.
taken to the hospital.
Which hospital? We don't know.
No, it's written, he was in fact taken to 3 numbers of hospitals.
Who says so?
Initially.
Where are the
Holbrook
treatment
Hospital was-
records? Where are the treatment records of those 3 hospitals?
Those
What
are-
kind of injury was noted? You say that it was a stab. Who says that it is a stab wound? Who says so?
Of course, the doctor, final doctor who had conducted the postmortem.
Autopsy. Does he
But,
say that it is a sharp weapon injury?
It's.
Because it is a surgical wound which he has opened.
Yes, inside.
We don't know. For all we know, while undertaking the surgical process, that injury may have been caused. You are under an obligation to bring evidence.
But it will be in the case diary, those medical.
What should we do of the documents in the case diary?
I'll just see what are the exhibits made postmortem. No, they did not exhibit
The
those.
cause of that, your lordship, is important.
Pulmonary edema.
It's retention of water in the lung, whether that is due to the injury sustained or due to some infection or negligence of the doctor in giving treatment.
But the fact remains, he was taken to Dhalpur Civil Hospital. Then he was sent to North
First, he was sent to North Lakhimpur.
Then Tejpur Mission Hospital, 3 hospitals. Tejpur, he died.
Where are the treatment records? The bedded tickets? What observation was made when he was taken to the first hospital?
I can show it from the,
And
it's
your
not
lordship, from
exhibited.
Lakhimpur to Guwahati is very doubtful when Dibrugarh is nearby to Lakhimpur. They would never refer to a patient from Lakhimpur to Guwahati when Dibrugarh is nearby.
And 313 admitted. 313 Lordship will
What
see
admitted?
page 27.
Yes.
It is true that I stabbed. But
I
rest of,
stabbed.
Not stab, your lordship.
it's an answer to the question
Yes,
number.
rod got inserted.
Insert.
That is right.
But
He
whether
said-
that is the cause of the death, we inserted on the flank, that is on the side part of the body. Between
All
the,
right, we'll see what can be done.
No, the other question I stabbed, that Lordship has found the answer. He had also said it is true that I stabbed.
That
This is
page-
page 27, last answer. It is true, but the rest of the statements are false.
your lordship is
So
just.
it will go in 304 part 1.
Your lordship, only one submission. Why I'm praying for part 2 is that there is no motive. There is no, whether he had aimed to blow on that vital part of the organ.
Abdomen is a vital part. He
Not-
goes to the house, brings back the rod. That is
Yes,
sufficient
But then he hit
indication.
on the hand, your lordship, first. So the intention, whether he had intended to cause
We'll
that
see, we'll
particular.
see.
And your lordship, in that regard, I have relied on 3 judgments which I have given call.
You already given copies, we'll take note of.
I've given the citation, your lordship.
You've given copies of these copies are there.
Okay, your lordship. 1999,
Just need saying.
yes, sir. One is for the exception under 3024. That is-
2022-6, 2022-4, and 2022-2 SCC.
No.
There are 3 judgments. Additional you have given.
No, I've given 99 SCC 1428, your lordship.
Give the list again.
Yes, your lordship.
As far as exception 1, it will not come. Provocation is nowhere proved. But exception
Provocation is
4,
there. When he comes out, he pulls out a tree
Tree.
branch and tries to hit him.
there was already an
Altercation going on.
So-
We'll see.
Yes,
All right.
I'll give the list, your lordship. I've relied 1 for 302 and 1 for 304 part 2.
We'll see.
Yes. Oblige, your lordship.
Judgment reserved. Okay.
She's for the informant.
Okay, you have to say something to say?
Report as PW1, you know. In front of me, only incident occurred.
He doesn't deny, he admits the incident.
Yes.
It is 313, but
Yes.
fight was going on. The deceased picked out a tree stump, tried to hit him,
Yes.
and then he hit the rod on his abdomen.
Yes,
So that is sudden quarrel.
yes.
304 comes into picture.
Yes.
Very well, we'll see. Has he been awarded compensation? No.
357,
Yes, they have awarded
Already been
compensation.
awarded.
Yes, it is left to the district legal service.
They must have done it.
No.
Oblige, sir.
Item 27.
Nobody there for the other side.
My lord,
There was a caveator.
on the last occasion, my lord, there was a change in councils representing the read petitioners respondents hearing.
We'll wait. Someone will come in.
My lord. Matter pertains to my lord, non-payment of land acquisition compensation on account of establishment of Raj Bhavan Governor House nearby. Way back in the year 1975.
No one has filed, put in appearance on behalf of the respondents. The matter is deferred by 4 weeks.
My lord. I'm obliged.
Item number 28.
What is the matter, madam?
It's relating to engagement of a Anganwadi helper lordship. Okay, I'm for the respondent.
Opponent list of 6 weeks.
Must be that.
Done. No more cases?